We have our panel with us, our legal experts here with us today for Verdict Watch. Kirk Nurmi, a former attorney of Jodi Arias, a high-profile lawyer in the area. Mel McDonald, retired judge, prosecutor, U.S. attorney for the District of Arizona as well. Taylor Larson, Charles Vallow's former attorney who helped file his divorce paperwork against Lori Vallow back in 2019. And obviously this case is not just about Vallow Daybell, but Charles Vallow. We remember that. Rachel Smith, special prosecutor in the Idaho case against Lori Vallow back in 2023. That trial was a long 6 to 7 week ordeal. Lori Vallow Daybell was found guilty of killing her two youngest children, JJ Vallow and Tylee Ryan, also conspiring in the murder of Tammy Daybell, the first wife of Chad Daybell, who is now on death row in Idaho. You guys, thank you so much for joining us. Rachel, let's start with you. What do you think about today, the jury taking an early day yesterday to really recharge?
You know, that shows this jury's very thoughtful. They've had a lot of information thrown at them over the last 2 weeks. They have to be aware of the pressure, it's my understanding they come in and out of the door with everyone else. So they've got to see the lines. They've got to see the reporters. They know how important it is. So taking that pause, taking that minute to approach things fresh, rested is a sign of a really thoughtful, thorough jury. And it's the right thing to do. We forget that this is an important part of our making sure our system works properly. And it's clear to me this jury's taking it very seriously.
All right, Judge Mel McDonald. Hey, I appreciate you staying on with us as well yesterday, and all of you guys, of course. But Mel, it was your wife's birthday yesterday? Oh, unmute the mic, Mel.
Oh, there we go.
Hello. Unmute your mic. Keep it on mute.
All right, I'm figuring it out.
We got all the time in the world, though, as long as the jury's in deliberation, so it's all good.
Yes, I'll be paying the price yesterday for not spending the time with my wife, rather being on here. I'm trying to remain mute around the house.
Okay, so you are, but you're not sleeping on the couch.
Close on the floor.
All right. Well, you know what are you thinking? This is not too surprising, is it? I mean, you said you think we'll have a quick verdict reached.
Yes, I do, and I'm not surprised at what happened yesterday with the jury breaking for the day. When you go into the jury room, whoever was selected, the foreman, the question would be, what should we do? It's going to take one or two people to say, hey, let's just go home and start tomorrow. They see the packed courtroom. They see the pressure that's on them. There's no rush. We don't have to do this. Let's go home. Let's digest the arguments and go home, unwind, come back tomorrow, and we can devote tomorrow to doing this. I think because of the obvious high-profile nature of the case, they want to be conscientious. They don't want to run in 10 or 15 minutes. Right. They want to take time to discuss and explore the evidence. So I'm not at all surprised by this. My surprise will be if they don't have a verdict by the end of the day.
All right. And with that said, it is 10:30 a.m. Mountain Standard Time right now. Robert, throw up the clock. The jury now on the clock deliberating about a minute in. It should be officially at 10:30 a.m. Now, we'd assume they're on time, but 10:30 is when they're supposed to report and deliberate. So you guys all see that there. We will be tracking how long this takes. Mel says it's not going to take too long. Kirk, what were your thoughts on Lori Vallow Daybell's closing arguments? I'm sure you were tracking this yesterday.
Yeah, there wasn't much to it, right? I mean, she got up there, she said what she wanted to say. I don't know that there was any real constructive argument to it. Not, to me, a firm response towards anything Ms. Kay said during her closing. And we saw part of what I kind of assumed we would see anyway, is that her attempting to testify throughout her closing argument that got shut down. I imagine, there might have been a lot more Ms. Vallow wanted to say if, she was not objected to, but we didn't see a real powerful closing argument. I mean, the only, points I guess she made, and we saw her do this a little bit with the lead detective, was related to some of the evidence that wasn't collected. But there wasn't a real strong argument related to that, tying it to reasonable doubt. There wasn't anything related to the conspiracy, right? She went back to this theme of this is a family tragedy, but there wasn't anything related to what Ms. Kay was pointing out related to the cell phones and the coordination with her brother, as well as her, text messages between her and her then boyfriend, Mr. Daybell, regarding the insurance money and anything else. She did not really make any headway in that regard. So that's why, it all agrees with, I agree with Mel that I'd be surprised, if the jury didn't reach a verdict today. I make them going home last night makes sense. They all want to look their best when they're interviewed by Justin Lum. So, we'll see a verdict today, and we'll see Justin Lum with those sharp-dressed jurors, I'm sure, later.
Thank you, Kirk. Now, Taylor, we wanted to know if she would address the religious text, but really it was just a Nephi text that she tried to spin as a positive message. But there are so many messages about Charles being possessed that, the jury has to be wondering, how is this happening? This lady was talking about her husband, and Charles, who you worked with closely, him being your client. Just, did you think she was going to somehow try and untangle that?
I thought she would a little bit, because she pressed, Nathan Duncan so hard on, the difference. There's 4 different Nephis in the Book of Mormon, and you don't know which one I was really talking about, or share some other story that, from the Book of Mormon about Nephi, other than the one that was to kill Laban, which is what Trina Kay has been, using it. She started with it in her opening, and she used it in her closing. So I was kind of shocked by that, but also I think that if you look at it from a juror's perspective, obviously that's some pretty insane, bizarre stuff to hear about zombies and, possessed person with names for these, demons or entities that are possessing the body of Charles. And even if there were members of, the Church of Jesus Christ of Latter-day Saints who are on the jury, they're gonna know right away, like, oh, that's not what we believe in. This is craziness, and this is delusioned.
I want to ask all of you real quick. So we've talked a lot about the jury, what they know, what they don't know about Lori in this saga. But we also heard the jury ask a number of questions after several of the witnesses. We heard the judge yesterday mention, look, if you have questions, the jury, submit them in written form. What do we take if the jury comes back this afternoon with a series of questions? What, as Mel, I'll start with you. What should we take from that? What should the Trina Kay and or Lori's defense team, what should they take from that? And are more questions good or bad when it comes to possibly getting a verdict? Mel?
Actually, quite frankly, I would be surprised if they ask any questions. I think the case has been laid out. I mean, the witnesses are 19-0. Lori has not really responded to much of anything. The relationship with Chad Daybell, the messages, all of the information that came out in the trial, it hasn't really been addressed. Closing argument was time to go out and pick holes in the state's case. And there's been no holes that have been picked into it. 1 or 2 minor points, but when you look at the standard of beyond a reasonable doubt, I had difficulty finding any doubt in this, and I can't see where the jurors going in there with the overwhelming evidence, the text messages, the videotape, the recordings, the obvious motives of $1 million that now she didn't get. All of these things, her failure to call any witnesses or to go through and address any of the points, I don't see that there's going to be a need for a question.
Do you, Rachel? Do you remember if your jury there had any questions and what you guys maybe were planning on if that would have happened?
We did have questions. They were focused mostly on the firearms, the shooting at Tammy predominantly. And so we were prepared, but the court's hands are bound in what they can answer. They are bound by the evidence. They are bound by the information that is available, and the court can't do anything to interpret evidence. So that's pretty much universal around the country. So if there are questions from the jury, we often read into them. Usually it's a sign that there's one or two jurors that need to be convinced of something, which was the true in our case, as we later learned from the jurors. So if there are questions, it'll be a couple of people who are maybe struggling with the legal concept of circumstantial evidence. And so while I agree with Judge Mel that that case was laid out very methodically, very detailed, with very clear conclusions, it just takes one or two. And if we stop and think back to a lot of the questions in voir dire by Trina Kay, it was about circumstantial evidence, the difference between physical and testimonial evidence. And that was designed with the purpose to find those jurors who can't consider convicting on circumstantial evidence alone. So I think in this situation, much like in Idaho, if there are questions, it'll be the regular jury making a effort to reach out and just assuage the concerns of one or two. I'm not doubting the strength of the case. I know the strength of the case that was laid out very methodically and outlined very methodically in closing argument. But if it's one or two, it'll usually be a question designed to assuage the concerns of one or two jurors.
Hey, Kirk, if Lori Vallow Daybell is found guilty, we expect an aggravating phase. Maybe, I don't know what's the proper term for this portion, but the prosecution will discuss aggravating factors. Lori can talk about mitigating factors. For people who don't know, how does this play out in general terms?
Right. Well, there's a sentencing range that the judge is to kind of give a framework for it that the judge can use. And there's a presumptive term within that range. In order to go beyond the presumptive term, aggravating factors have to be proven to a jury. So what will happen then, and I would say it's a when, not a if, she's found guilty. When she's found guilty, then the jury will hear of other convictions, things of that nature. And those, most of the time when there's other convictions, for example, a defense attorney would simply, acknowledge those, stipulate to those, what have you. I don't know if we're going to see Ms. Vallow fight those or not, but they're pretty self-evident, self-actualizing. She can make her other arguments, and I suspect ultimately the jury will find aggravating factors. I suspect, though, in this case, it might go a little different in that I suspect that the judge will, once those aggravating factors are found, not actually sentence Ms. Daybell till after the proceedings with Mr. Boudreaux are closed. So we're going to see it a little bit different there. We're going to find that factual basis, that conclusion laid by the jury, and then probably that moment of sentencing that a lot of people are waiting for will actually be held off until both justice is received for both victims.
And we are going to talk about that second trial in a little bit because Judge Mel had a bold prediction last week. We'll get into that. But first off, we talked about the Nephi text and how Lori played that to the jury, how she gave her narrative on that. Let's listen to Bite 27.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime.
Judge Mel, your initial thoughts when you heard this line and how she said it, her tone of voice too, to the jury.
Well, let me say this. I saw the microphone was about 6 or 7 inches from her face. I'm grateful that she wasn't Pinocchio, because she would have knocked the mic over with that pitch. Very unconvincing. You look at the presentation. I mean, the thing that has just boggled my mind is her attitude and demeanor, which goes right back to my belief of what a fool she was to represent herself. She's very bright, very articulate. And when she attacks the woman who goes out with her husband the night before about being married, and then her play now on religion to somehow suggest that this play on Nephi was somehow using religion against her. I mean, from day one, the slaying of Laban and her text messages, very unconvincing.
Taylor, I want you to talk about this Nephi story. Are there really several versions? And in this, I'm not familiar, but if you could educate us on this, since you are a member of the church, of how important Nephi is.
Yeah, I mean, Adam did a great job kind of explaining it in his testimony. And then, Nathan Duncan, Detective Duncan, did so as well when he talked about, he, over the past few years, he would go and he would ask members of the church about Nephi, and that was the first thing that would come to him. Nephi, as Adam said, was the first book in the Book of Mormon, and he was a prophet. And there there are several different stories about him that members of the church, that stand out to the members of the church. Laban is just the first one. That's the first, major story of him following, God's command and achieving something that was very important, because his family was fleeing Jerusalem before it was destroyed, and they needed to obtain the records that Laban was keeping. And so, and Lori is right. There are 4 books of Nephi, because of descendants of Nephi being named Nephi, which is not uncommon in today's world either. So people can relate to that. But for her to say that this, like Mel is saying, try to twist the religion and saying that she's been targeted and they're using this text out of context. But when you look at the aggregate with all the text messages and all of the religious stuff, all the castings and everything, it makes sense that she's, when she says that, I'm going to be like Laban, that is the story that they are talking about and referring to is, or that I'm going to be like Nephi and kill Laban. That's the story that they really are referring to. There isn't any other stories that kind of align with this saga of, Charles being murdered. So, I think Nathan Duncan was correct. And I would tell you, if you polled members of the church, they would often say that, Nephi was the guy who killed Laban. So that's 100% accurate. And for her to try to minimize that, like she tried to throw in there that she was, praying for her husband because they were going through marital problems, when we know that's kind of her trying to explain the castings, is just disgusting to me.
If I could jump in there real quick, I agree, but I don't understand. I guess I was not surprised at all by the way Lori tried to do that. Religion has always been a manipulation tool of Lori Vallow. When she could use the bizarre beliefs and ideas and use Nephi as a way to get Alex to act, she did it. So now she's using it in a different way albeit I would argue inconsistently with the jury. Manipulation is less a set of beliefs and more a set of a tool that Lori uses to get what she wants. She could tell that jury is going to see it's bizarre. So the best way to use it is to turn it into something positive. So I work, a lot of the investigative team in Idaho were members of the LDS church. So everybody on that team knew very clearly, and Rob Wood, lead counsel on the case, had been a bishop in the LDS church. So they all knew instantly which book or which version and original story about Nephi she was talking to. So had she been talking to a group of people she knew shared that belief system, she might have done it differently. But she's trying to normalize it. She again is trying to use religion as a power tool. That is textbook Lori Vallow Daybell. Religion is less about what maybe she believes and more about what she can get people to do with it.
It's funny you guys talking about this. So I went back and looked yesterday. The term Nephi was brought up 24 times in both closing arguments. Trina mentioned it 19 times. So she hammered that home, and then Lori came up, mentioned it maybe 5 times. But clearly that was something Trina brought up extensively in her closing arguments yesterday.
And Taylor, I want to ask you, when Charles was working with you and telling you these stories, Moroni was brought up. Can you tell us about the past lives and what Lori was saying to Charles?
Yeah, I mean, she told him that she had been married to so many different biblical figures, not just Book of Mormon figures, but biblical figures. You know, I know that came out in Chad and Lori's trials in Idaho about, you know, Chad thought he was James the Just, you know, and that was the James and Elena story. But she told Charles that she was married to Moroni, and even that, you know, Charles showed me that she, throughout her Book of Mormon, had anytime a mention of Moroni was, she had drawn a heart around it. And so that was kind of interesting to me, and more like my take on it when he's telling me this is that she's got mental issues. She's either, you know, manicking or something, because that's just not something that a normal person would believe and know. And then, you know, then he starts telling me about multiple probations and sending me, you know, articles that he found that Chad had sent to Lori about multiple probations, meaning, you know, living in past lives and who they were in these past lives and who they're going to be. And now that they're translated, you know, and they can't taste death, it's kind of ironic now knowing that Chad's sitting on death row. And, you know, it's unfortunate that Lori won't be able to do that, but I think that Lori, that would be the easy way for her. I'm glad that she's serving consecutive life sentences, and I hope that gets added on, you know, shortly here after we get a verdict today.
Kirk, in all the trials that you've seen covered, you know, in these several years, at one point we were talking about Lori being competent or incompetent. And now she's representing herself as her own attorney in a murder conspiracy case. Just how we got here. And she was incompetent in Idaho for some time. I mean, look how far we've come here with this saga.
Well, you know, we have to step back a bit when we talk about this, Justin, because one of the things that, at least in Arizona, if a criminal defense attorney, a great one like Ben Taylor, who I see up on the screen there, has any doubts that their client is competent, whether or not they can effectively assist in counseling and understand what the proceedings are going to be, what have you, they have an obligation to explore that through what we in Arizona call a Rule 11 pre-screen, to assess whether or not they are competent to stand trial. And you go through various phases of that, and Idaho may be a little different, but we know she was in treatment, what have you. You get to a point where someone is competent to stand trial, which is really a low bar here, right? We're not talking about absolute sanity. A person like this can still have some of the delusions, the religious ideations that Taylor and Rachel mentioned a little bit. They can still have that as long as they understand the proceedings against them and what each of the parties is supposed to do. And once they are competent to stand trial in that very low bar, there's really not further impediment for them to represent themselves. As long as they're competent to stand trial, there's no test that somebody has to undergo. There's no legal test. I mean, judges and Mel's probably, given this speech to talk about you're going to be held to the standard of an attorney, things that we saw Judge Boreski do earlier. You're going to be expected to cross-examine witnesses, call witnesses. All these sort of things are put before the person as a cautionary tale, but that doesn't mean that they have to, like I say, pass some sort of test or anything in order to represent themselves. They're competent to stand trial, then they're de facto competent to represent themselves, whether they, really are or not. But from a constitutional standpoint, they're competent, and that's it. It's a low bar, Justin.
Good point. And just for everyone watching, we've got more than 1,000 people watching you guys, so great job so far. We have a poll question on our Fox 10 Phoenix YouTube channel. The question is, do you believe the jury will convict or acquit Lori Vallow Daybell? 13,000 votes so far, people either voting for convict or acquit. Now, also want to mention, we got Benjamin Taylor here joining the panel. Welcome. Good morning, Benjamin. I know you had a busy day in court, and we thank you. What are your thoughts going into Verdict Watch right now?
My thoughts are just wondering what the jury's thinking. Like yesterday, they went home early. They're back fresh this morning. So they're working hard. They're looking through all the evidence. And there's a lot of evidence to look through. And sometimes some jurors will say, hey, I want to be able to feel, touch, see, watch the video. So depending on what the jurors' personalities are, that's how long this verdict watch will go. Sometimes the foreperson will be picked. They raise their hand and say, let's take a vote right now. And they count 1, 2, 3, who says guilty, who says not guilty. And sometimes they can say not guilty, or sometimes they say guilty. And they can say it really quickly, and it can be over with in a matter of less than an hour. So a lot depends on what this juror's personalities are, what they want to do. They want to go through all this evidence, or do they want to just get it done and get it done quickly? But I agree with the rest of the panel. We will have a verdict. The verdict will most likely be guilty, unless, as Kirk knows this in his Jodi Arias trial, unless you have like one juror who stays strong and says, hey, I don't want to convict. Most likely we'll have a guilty verdict sometime this afternoon.
All right. Now, Judge Mel, let's get back to this prediction. You talked about the second trial regarding the shooting at Brandon Boudreaux, the attempted murder case, and also a murder conspiracy charge against Lori Vallow Daybell, that there's a chance that a charge would be dismissed if we get a conviction here for this case regarding Charles Vallow. Talk about that.
Yes. When you look at the posture of where Lori Vallow is now, death penalty is off the table on all of the cases. In Idaho, she's looking at 2 life sentences without the possibility of parole. In Arizona, with the conspiracy to commit murder, if convicted, she's looking at about 25 years. A judge, and I'm not sure whether the sentence will be served in Idaho or Arizona. My guess would be in Idaho. But a judge can then take the sentence, if it's going to run with Idaho, and make that sentence run consecutive. So my point is, there's nothing more that can be done to Lori Vallow than would be done if she's convicted in this case. After an aggravation hearing, I am confident that, given the history of the case, I mean, Lori Vallow Daybell is a serial killer. One by one, she kills a husband. She's involved with the death of her children. She's connected with the death of Tad Daybell's wife. She's connected with the shooting of the husband of her niece. There's nothing more than a new trial could do to Lori Vallow, other than give her more time in the sun to let her face be seen on the television and for people that can give her attention. It would also be very costly and expensive. Jury selection and that trial would be a nightmare. You've got to be living with your head under a pillow if you haven't heard about these cases. And so I would suspect, and I only spoke from my standpoint as a former U.S. attorney, if I had similar cases that had come into me, the fact that Boudreaux was not hit or killed, it was terrifying that there's nothing to be gained and nothing but extra expense in that. Lori's not going to be affected the least bit other than maybe get attention. So my thought would be, we've got her in Idaho, we've got her in Arizona, we've got the most that we can ever get. She's going to die in prison. Let's not waste the resources.
And you could have Brandon Boudreaux speak in like a penalty phase for this case. He can get, he can say what he needs to say, but he'd, I would assume, have to be okay with not prosecuting her anymore. But she said that there's a chance that he could still get his justice in a way, in this theory. Anyone?
Yeah, I was just thinking about what the judge said. I think Brandon is probably one of the least spoken about counts, but it's really the one that got the case going. He has waited years for his day in court and justice, and what devastation happened to him and his entire family. It destroyed his marriage. It put him at physical risk. He was friends with Charles. So while I agree with the court, with the judge, in terms of, if you measure it in terms of cost and time and sentence, if that's the rubric we're using, I agree with him. If we also see it that people are entitled to their day in court, then Brandon hasn't had that. Mm-hmm. So I think it's going to come down to priorities in Maricopa, and it's going to come down to whether Brandon has his day in court. If in aggravation he's allowed to speak, it is part of the sentencing that enhances Lori's sentence and takes it beyond that presumptive scale to the maximum, and that he has an opportunity to have his information factor in and a measure of accountability for what she did to him and his family, then I would agree that perhaps we've seen the max. But if we want Brandon and want him to have his day in court and some measure of justice for what happened to him, not just in terms of the length of Lori's sentence, but in terms of the public recognition and accountability, then we'll see a second trial.
And Kirk, do you feel like this case might be just as strong as the case involving Charles Vallow because you have a witness and victim who's alive to tell his story and get up there on the stand?
Yeah, I mean, each case is going to have its strong points and its weak points, but I tend to agree with Rachel more in the sense that the county attorney's office seems to be, and I don't know that really everything that Brandon would have to say, Mr. Boudreaux would have to say, would really come in at an aggravation hearing until the actual thing is processed through and we see everything with the county attorney's office. I feel like they think that they have a strong case. You're right, having a victim up there, having a surviving victim up there that can tell their tale is powerful. It might be cathartic for Mr. Boudreaux to do that, to confront Lori in court. So while I think some of the things that Judge Mel said are well taken in terms of giving Lori the spotlight, what have you, I think the county attorney's office has shown, because you could make the same arguments that there's no practicality to this case because she's already serving 2 life terms in Idaho. But I think she's here, the trial is scheduled, and having gone through jury selection in a high profile case, not once but twice, one that was in the media for about 6 months, it is surprising to see that there are, to use Mel's terms, people living under that pillow that either haven't heard of the case or don't have, and the standard is not having heard of it, but not making judgments about it, not having preconceived notions about it. So there's a real possibility that they will be able to sit a jury. It might be a little more difficult this time with all the publicity that's been focused and saturated in Maricopa County now, that combined with everything else. But, it's something that certainly can be done. And we've seen in this case a level of efficiency with the prosecution of the case but we're talking about a couple weeks of court time. She's already here. My guess is the county attorney will continue to pursue it even after this guilty verdict.
If I could just add one comment to that, prosecutors every day do plea bargains where there's multiple defendants. All the time, you will have people that have been victims of robberies, that have been victims of assaults, that as a part of a plea bargain, their case is considered, but they plead to other charges. So it is very, very common in the criminal justice system, barely because you've been a victim, the prosecutor will consult with you and they'll discuss with you and get your feelings, but the ultimate call is theirs. And what the criminal justice is, if Mr. Boudreaux had been hit or killed, I can then see an argument as in this case. Clearly, you want to proceed. A life was taken in cold blood. This is something you want to see. But in the plea bargaining process, every day, victims don't get their day in court in the criminal justice system. But with the plea agreement and the sentencing, you look, what are the consequences? The goal of Brandon and all of the other people, those tragic people that died, is that Lori preferably should have faced a death sentence, but since that's off the table, to go to prison for the rest of her life, never be paroled, never be eligible for parole, that would be accomplished with a conviction in this case in 2 states. So even if there was a reversal of one, you've got the other. So to me, it's not a matter of not wanting to have justice for him. I can understand the turmoil that he went through. It's just in the interest of judicial economy and the fact to move forward and the fact that you've got Lori as punished as best you can, it doesn't make a lot of sense to move forward.
And just real quick, since we're talking about the Brandon saga, what's not lost on people following this case is that Melanie only testified in Chad's trial, was not called. This is Brandon's ex-wife here, was not called in this trial. People wanted to know, since her texts between Lori and her were brought up in this trial. I would almost imagine that she would have to make an appearance in Brandon's trial, and people at home are wondering why she hasn't been charged. I don't know if that factors into the decision to go ahead and move forward with the next case, but there are a lot of people who would love to hear from her, or at least have her questioned again, but it's specifically in these cases regarding Lori.
And to piggyback on that, Rachel, I mean, clarify, Melanie was going to testify in the first trial. There were things that happened, I think, in the first trial where she said she watched Brandon's testimony. So she really has not taken a stand.
The way Judge Boyce implemented some rules on publicity affected whether we could call her. And so, which is the rules were very clear, the parties knew, and so that affected our ability to have her on the stand. And so it's a convoluted situation with Melanie, but to take it to another level, suspecting somebody's participation, having belief on involvement, maybe some corroboration of that belief is not enough to charge somebody. As we're seeing, the charge of conspiracy, circumstantial evidence is a tough one to go forward. It's some of the toughest cases you can have out there as a prosecutor. So if there is not enough evidence that somebody contributed to the conspiracy, aided and encouraged in a concrete way, there's just not enough evidence to prosecute them. And so I think her connection is much more direct to the shooting at Brandon. Her the motive that Lori had was financial, based on her beliefs about what Melanie could contribute. So should the case go forward with Brandon, it was much more likely that Melanie Boudreaux would testify. And again, the court, that the prosecution is going to be doing an analysis. How strong is my case? Do I have to offer anybody immunity? Do I have to offer people the opportunity to testify with counsel present? And that factors into a willingness or a desire to settle or dismiss. So the next few weeks we're going to see a lot of evaluation being done behind the scenes by the prosecutors in Maricopa. But I would predict that if they go forward on the Brandon charges, we will see Melanie Boudreaux testify.
Yeah, and now Melanie Pulowski. Yeah, it seems like it was just yesterday we were talking about their divorce, the shooting at the Tesla. Benjamin, I'm going to go to you. A lot of people feel like, and maybe these are people who are avid followers of this saga, this case, feel like Trina K may have left a lot out there that was not presented, but there's just so much in this wild case. Do you feel like she checked everything off and presented the best evidence and finished off well in closings?
Yes, the prosecutor presented the evidence that they needed to present. What you don't want is to have this trial drag on for another week and another week, because the jurors get tired and they get bored, and you never know. I mean, she was already way ahead of Lori Daybell in this case. There was no need to call up more and more witnesses. When the iron is hot, you strike, right? And that's what she did. She's already ahead. There's no need to, fumble the ball. She could have fumbled the ball. She called up the wrong witness, right? So her closings, the number of witnesses, it seems like there's a lot. Of course, the viewers would want to see more and more witnesses, but Rachel could speak to this too. When you do prosecution or defense, there's a strategy here. And as a strategy, if you want to make sure that you get your evidence in, you don't waste the jurors' time, you don't bore the jurors, and then if you have enough, you sit down and you shut up. There's no need to keep talking, and there's nothing more to add. So I think the evidence is overwhelming. Lori didn't testify. She has an uphill battle here, and that's why we're predicting a verdict this afternoon.
And really what she honed in on was words and actions and really the demeanor of Lori. And I think that is the most simple way to put it. How did Lori react to the shooting of her husband? So let's listen to that again, Robert. Bite 20, Trina's closing arguments.
Finally, think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm, no questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened, and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that.
Okay, now, Benjamin, talk about witnesses and a lot of witnesses we may have wanted to see. I know a lot of people are saying, why isn't Taylor up on the stand talking about that divorce filing from 2019? Obviously we want you here, but you would have been a great witness. I think that any prosecutor would agree. But Taylor, besides yourself, is there somebody part of that inner circle, without hinting to names, but who would you like to have seen testify, adding on to the list of 19?
Yeah, I think Zulema would have been good to hear from again. She can speak almost for Alex's perspective, being so close to him, being married to him, since Alex is dead, obviously, and is not able to testify. So I would have, and Zulema would have been able to really kind of drill down on explaining the bizarre religious stuff and the zombies and the castings, which is what she did in Idaho when she testified. So that would have been a good, I think, one person that I would have liked to see. I understand Benjamin's point, and I agree that at a certain point you kind of have to just keep it moving, and it's best to just shut up. That's something that you learn in law school, when you can overshare and overthink and really burn the trier of fact out. So, I think Zulema would have been nice, because the one thing that Trina K didn't really touch on that I was waiting for it to come out is the fact that, Lori has said that, or, whether it was Chad or Lori said that Alex was, her protectorate, and her angel, her destroying angel. And, we referenced that in the divorce filings when she told Charles, don't come back here. Don't get in the way of my mission. You need to take JJ because he's in the way of my mission. And if you try to get in the way, I have a destroying angel here who's going to kill you and bury your body.
Wow. Yeah, that is some dark stuff. Now, Rachel, why might those two, I specifically talking about Zulema, Melanie Gibb, not have been called? Especially they lived here in the Valley.
I think if you're trying to keep the case very focused on Charles, not on the entire conspiracy, not going too down into the weeds on the religion, then you limit who you call. Benjamin, I couldn't agree with Benjamin more. You have to make a strategy choice. Trina very clearly cut things that would open the door to other issues. She kept it very, very focused on Charles, very focused on wanting Charles to die, why Charles needed to go. And the minute you bring Zulema in, the minute you bring Mel Gibb in, or even Melanie Boudreaux, you open the door to a whole bunch of other and to the entire conspiracy. So 2 reasons: keep it clean and focused on Charles. And the other, we don't know what the judge's rulings were behind the scenes on what else they let in. And so the judge could have given some instructions on don't open doors to Tylee, don't open doors to the multiple other people that were found to be dark spirits. It wasn't just Tammy, it wasn't just Tylee, it wasn't just JJ, it wasn't just Charles and Brandon. So Mel, Gibb, Zulema all have information about that bigger picture. And the more you encourage a witness, hey, the judges said you can't say that, the more you risk a slip, the more you risk them opening. So in order to keep a very narrow, very clean, very tight case, you limit who you put on, and you try to stick with the best witness on the single issue you're allowed to get into. So we're seeing a strategy choice of the prosecutor to keep it concise, keep it clean, and possibly follow a court's order.
Interesting. Yeah, it appears that Lori and Chad, whoever they just didn't like, they deemed them dark instead of light on any given day. Let's take a look at our poll question that we've pinned to our chat. Question: do you believe the jury will convict or acquit Lori Vallow Daybell? Right now, out of 14,000 votes, 97% say it will be a guilty verdict for the so-called Doomsday Mom. 97%. Wow. What do you guys think about that? Kirk, is there a chance? Does she have any chance that one juror is just on the fence here?
It's hard for me to conceive of how that could happen. You never know. I mean, we select juries as individuals, but they act as a group. So the group dynamics, if they feel like they're being bullied or pressured, they're on the fence, maybe they entrench their heels a little bit. That's possible. I mean, so in that regard, there could be a hung jury, but I just don't see it in this case based on a lot of what we've talked about. When we talk about the possible elements that Rachel was addressing and Taylor a little bit as well of these other witnesses, I think one of the ways that I look at trial practice, I used to tell this to younger attorneys, this is like a train leaving the station, right? If you're the prosecutor, you're trying to go from presumption of innocence to guilty. And you don't want to take a long and winding road, and it's not necessarily a scenic journey, right, where you go into everything, because that long and scenic journey can create a lot of rabbit holes for people to go down and become entrenched in and say, well, what about this thing, using Taylor's suggestions, Zulema, what about one thing she said? Well, are we sure this woman's sane? Are we, and they start bringing up questions of that. Is she really sane enough to bring a conspiracy forward? And those kind of things can serve as a distraction. So when you're driving that proverbial train from, presumption of innocence to guilty, you want to move as straightforward as possible. And that's why I think this kind of eliminates that possibility within the jury room. And that's why I think we're seeing the 97% agreeing with this panel. I don't know what the 3% are seeing. Maybe they just want to be contrarian, but I just don't see it. So yeah, I think the case is laid out pretty good, and I guess I'm happy to stand firmly with the 97%.
Yeah, and Lori Vallow Daybell tried to turn the tables on Chandler police and call their investigation not good at all. Let's listen to what she said in closings. By 26, Robert.
We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later.
Judge Mel, what do you think about that? Judge Mel.
Oh, I'm sorry. I thought you said let me just wet under the thought. The 97-3, the 3 is for acquittal. That means 12 people vote not guilty. So for the 3% that voted that way, we may need to get an analysis of them. They couldn't have been watching this case. 3% ought to be a hung jury. There's no way. I would bet if you got a better chance at the lotto than an acquittal. So as to that, the segment you played was probably the best part of Lori's entire presentation for the entire trial. You'll learn, and I've tried dozens of murder cases, there are always going to be times where the police will not do something. Oftentimes they're acting with what they believe at the present time. Hey, it looks like a self-defense. Tylee made these claims. He made these claims. There is a minor injury, and they don't do some things. But the bottom line, the evidence is so overwhelming with what was done, and the evidence that's in there, and the evidence that she didn't respond to. That that was Lori's best part of her closing, but very unconvincing.
But and we had this conversation at the beginning of the trial that we figured Lori didn't want to deviate from this self-defense idea. We know that police missed a few things. They took Alex at his word. Yes, I was the one that, shot and killed Charles, and claimed self-defense. And there were things that maybe they could have done differently in that investigation on July 11th of 2019. Again, hindsight. But it was interesting because she only touched on it briefly through the trial, and we weren't sure how far she was going to take that and say, look, you guys didn't do a thorough enough job in this investigation. But then you're like, well, but self-defense is the crux here. You need for the jury to believe and understand that this was self-defense on the part of your brother, right? Like this was one of those doors. There were a number of doors that we thought she should not open. And unless I'm wrong, this was one of them that she should have just let that dog lie. No?
I mean, I would be very interested to hear Kurt or Benjamin, but my point of view is that's pretty much all she had is their failure to do, in quote unquote, her words, a thorough investigation shows their belief it was self-defense. She didn't connect that dot the way I know an experienced defense attorney would. But to me, I agree with Judge Mel. It was one of the highlights, if there are any, in Lori's closing argument, which was they didn't do that work Maybe not because they're incompetent, but because they believed it was self-defense. But I would, of course, love to hear what Kurt or Benjamin have to say about that.
Yeah, George, I can weigh in on that. I mean, I think if I was trying this case, the first words out of my mouth would have been something to the effect that you cannot have a conspiracy to commit murder unless you have a murder. And in this case, we do not have a murder. We have an act of self-defense, and move it from there and focus on that, because that's obviously, you know, and say, ladies and gentlemen, you're going to hear in the jury instructions at the close of this case all the things that are required. You're going to see the state has not met their burden on those elements, and therefore my client's not guilty. And that would be my approach. I don't know if Ben has a different thought.
All right, right now. Sorry. Go ahead, Benjamin.
But yeah, no, I mean, I agree with Kirk and Rachel on that point. And the fact that, you know, she should have started out really strong to get the word murder out the jurors' heads and this focus on the self-defense. And she tried in her cross-examination, she tried to say, you know, nobody saw me there, you didn't hear me there. So she tried to reiterate that a little bit. But only one thing I would say is in her closing, she was kind of attacking, or she was trying to attack the Chandler Police Department. You'd be kind of very careful there when you do that, because a lot of jurors, when you do jury selection, people will raise their hand and say, I really believe cops, or I have a lot of family members who are police officers. And when you start attacking people, especially the police officers, people might go against you if people love the Chandler Police Department or people live in Chandler. So she has to be very careful on that. So I think what Kirk was saying earlier, focus on self-defense, keep it to that. And even though there are some mistakes here, but you can still say there's mistakes that were happened, but did not really attack the police department, or else the jurors will turn against you.
And there are many people in that jury pool, as we were sitting in jury selection, that had family members that worked in law enforcement or retired officers. But obviously they're still asked if they could be fair and impartial. But there was definitely a lot of people who had ties to law enforcement. She also said that self-defense is not a crime and that her family had a right to self-defense. Now, also to note, she mentioned Tylee and Alex in past tense have had the right to self-defense. But of course, it is the reaction to the shooting and the lack of a response to Charles. Taylor, would you say, like, just because you have the right to self-defense, jurors will wonder why she didn't do so much more?
Yeah, I mean, even if there was an issue with, some of the things that Chandler PD didn't do in their investigation, there are other points of evidence and facts that show that this wasn't self-defense. You know, the gun ballistics, that second shot, how's she going to get around that? How's she going to get around not calling 911, especially when she called Alex in the interim before they called 911, and her lack of emotion that we've hit it, so many different times on this panel. But her demeanor is not someone who just lost a husband of 13 years and was right there with her own children right there. So even if you have marital problems, you're still going to be emotional, and it's going to be an emotional reaction. And then to not even check on your brother, who supposedly was hit in the head by a minor league baseball player, a former minor league baseball player. There's things in there that overwhelm, as Judge Mellis said, the little, maybe missteps of the investigation.
All right, so this jury has been deliberating for almost an hour, starting just after 10:30 this morning. They will decide if Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder in the death of Charles Vallow. It's 11:25 here right now, and our Lauren Clark is in the courtroom. She's telling us that, normally, according to the PIO for Maricopa County Superior Court, that jurors will default to the schedule they've been used to. So lunch has been around noon, so they could take this lunch, talk about it more. They could decide they want to go to lunch right now. They could decide, let's get this done. Now that we're an hour in, Mel, what are you thinking here? Obviously, it's still early, right?
Yes. Yeah. What you've got to do, every juror in that room, when they finally come out with a final decision, want the public to know that it wasn't something that people just rush into. I think clearly they're going to want to go over some of the text messages. They're going to want to look at some of the videos. They're going to have some discussions. I mean, there's so much. We have all of that evidence preceding the killing, the affair, the relationships, the letters that Charles wrote to Daybell's wife, or the emails. You've got all the forensics of the day of the killing, and they've got to discuss that. Somebody says, well, maybe it was self-defense. Well, what about the second shot? Clearly, the forensics show that he was down. You don't shoot somebody twice in self-defense when the first shot disables them. And then I come back to her demeanor after is absolutely chilling. That is the mentality of somebody that has no conscience. That's got to be the kind of a personality of a serial killer. She doesn't care about her husband of all these years. She's unconcerned about what effect this has on these children. And has been noted by Rachel. She doesn't even check on her brother, who was instrumental in this. So there are things that have to be discussed, but I suspect they'll go to a lunch break. It'll go into the afternoon. They're going to want to go through and make sure that everybody's lined up. But the 97% are going to be proven to be correct at the end of the day.
And we had a lot of questions about Lori throughout this trial. We've had a lot of people ask why Lori continues and has continued to refer to Charles as her husband in the trial, but also kept his name in her name. Taylor, what did you think of that? We heard her several times refer to her as my husband, and then of course in her closing arguments mentioned, they're trying to turn a family. A family issue into a tragedy, into a crime. They're trying to turn a family tragedy into a crime. But again, this morning I got a few questions on the other stream about her continuing to use Vallow, even though that prosecution set up the fact that she is now and has since remarried. What did you make of all that?
Yeah, I mean, I think it's a shot in the dark on her to try to say, and I think it's strategic in part to always say that, my husband this, my husband that, we went out with my husband when we all know, and the jury knows, that she was having an affair with Chad, who eventually she got married to. They didn't bring in the timeline of how quickly she remarried, obviously, because that was probably precluded in previous rulings. But for her to continue to say that, I know that that's just strategic. I mean, we know from just back in Idaho when she was getting mad that people were referring to her as Lori Vallow. She wanted to add and make sure that she was Lori Vallow Daybell or Lori Daybell, so her actions speak louder than her words here in the trial, and it's nothing but more of a show from her.
Taylor, can I ask, I remember as of the end of the trial in Idaho that she had not legally changed her name to Daybell. That was with Mark Means and our parties that went back and forth on what her legal name was. And eventually Judge Boyce said, call her Daybell. So that's what we did. Did she ever legally change it after her marriage to Chad to add the Daybell? And that's just a weird little factoid out there. Do you know if she did?
Yeah, I don't know. I don't know if Justin knows that. I know that Justin in the past, and I won't speak for him or put words in his mouth, but I know that he's told me before he wasn't ever going to call her Lori Daybell because he never saw a marriage license until we got that. So, Justin, I don't know if you can answer that question, but that's an interesting factoid.
I believe finally in the Idaho trial, we saw a marriage certificate via Hawaii, right? So that she had finally been married to Chad Daybell. But she's been known as Lori Vallow for so long. We obviously call her Lori Vallow Daybell. It's her fifth marriage. But we wanted to, a place like Nevada, you can, as a public record, you could find that marriage certificate. In Hawaii, you need to be an immediate family member. I remember when we were digging into the case back in 2020, I asked Colby Ryan at the time if we could somehow get his help to get that marriage certificate. But, things were very different back then and tough. And obviously, we end up finding out ultimately that she did get married and did not report it to SSA. But that's what we know about that. So we'll call her Lori Vallow Daybell. It's been an hour or so now. And I guess the jury, they could take lunch soon, or they could just keep working. We're told they get a little bit of a stipend. I think that they probably are going to keep working because they did show up a little bit late. I don't know if they started exactly at 10:30. And also there's been a couple times where they haven't started right on time in getting to court. Can anybody talk about the mindset of a four-person and just how important that is, and getting everyone? You're getting 12 people together, 12 personalities, and you haven't talked about this with each other until now.
Well, Justin is doing a lot of trials, especially murder trials. The four-person is the key. I mean, that's the leader of the group. That's who's going to decide and take the vote. That's who's going to decide we're going to move a little bit faster or slow. The people need to understand, the viewers, that every single person in there, their vote is equal as the four-person, but the four-person has a strong personality. That four-person can twist your arm to make a person who's saying hung jury or not guilty into a guilty verdict, or vice versa. So the jurors will go based upon how the four-person's personality is, and how fast and how quickly the four-person wants to move through the evidence, or slow it down and watch every single piece of evidence. But each and every juror has the same rights and same vote as a four-person, but the four-person is very key because it will decide how quick and how slow this jury will move.
Yeah, that leadership quality, that is something that as a prosecutor, when I'm looking and trying to either strike somebody from the jury or try to insulate so that they're selected, those leadership qualities are really important. And when you have a four-person who has leadership and organization qualities, you see very thorough, very thoughtful questions, because they sign all the questions that come out. At least in most jurisdictions where I've been, you know who the four-person is. And I often will be my first question to the judge when he gives me says, hey, there's a question. I'm like, hey, who's the four-person? Who signed that? Right. So because that's a symptom, I couldn't agree with Benjamin more, of how deliberations are going to go. And the other thing I look for is this somebody that was making eye contact with me or the members of the team, or were they making eye contact with the defendant? Were they nodding with the defendant? Did they roll their eyes when one side or the other made an argument, or how were they responding to our witnesses? So that four-person is a barometer that when you got nothing else to do but wait, you kind of latch on to.
Yeah, I would love to interview the four-person for sure, all the jurors, and Judge Mel. I know you can talk about so much respect for a jury investing their time and doing their civil duty, especially listening to so much of this evidence, and basically their world and their lives get rocked out of nowhere. We do have a question from our viewers about after the verdict, when the jury is released, are they able to speak with the judge and ask questions, and just for their own knowledge, and find out more about the story, specifically Tylee and JJ?
Yeah, I have no doubt that they will eventually know that after the case is over. They have every right after their deliberations. The rules that govern the conduct of jurors are now over. The verdict is back. They're released. They can watch any news media. They can read anything they want to read. They can discuss with anybody that they want to discuss with the results of the case. One of the guests yesterday was an alternate juror. That is entirely appropriate. And oftentimes after cases, attorneys like to meet with the jurors and find out what influenced them. A lot of times it can be a great learning tool. If you're a prosecutor or a defense attorney, you can ask jurors, what did you think of this line of questioning, or how did you like my presentation? So there can be a wide open dialogue. Some jurors want to steer clear and they will leave and not want to make comment. But I would suspect that you'll find a significant number of people that are on this juror that will be happy to comment and will be happy to share the thoughts and perceptions that they had.
Interesting. All right. Well, George dug this up, this gem. My memory's not so good, but check this out. Posted this on, it was Twitter back then, March 8th, 2021. Chad Daybell and Lori Vallow's marriage certificate from November 5th, 2019 in Hawaii. Her attorney had filed it before a hearing, March 2021. So there you guys see, she declared the name Daybell. So I guess I considered her Lori Vallow for a long time, but this happened at the Anini Beach Park. We've seen the chilling wedding photos. We were first to report those photos and show those to viewers, as the kids, JJ and Tyler, were nowhere to be seen. They were not cooperating with law enforcement. They would not cooperate with law enforcement as Rexburg PD searched for JJ and Tyler just to make sure that they were safe. But there it is, Lori married to Chad Daybell, and we know she still wears some sort of wedding band and a hairband or something to symbolize her marriage. He is on death row, convicted of murdering those two children and his own wife, Tammy Daybell. Just a devastating story. She was Lori Noreen Ryan Vallow before getting married. I mean, we know about all her marriages. The jury doesn't. I mean, can anyone just comment? Rachel, I'll go back to you on this. As you were diving into this, you're brought on as a special prosecutor. You're flying into what airport? I don't know where you flew in.
Jacksonville,
and just what were you thinking as you meet Rob, prosecutor from Madison County, and he explains this whole thing to you? Rachel?
It was that experience was, yes, can you hear me?
Yeah.
Can you guys? Yeah, sorry about that. I don't know whether my connection is bad or not. Yeah, that experience will stand out as one of the most unique of my law enforcement career. I had done a background on the case and been submitted some of the reports right after I was hired. And so drive over the mountains into Rexburg, I thought a lot about it. I listened to some of the recordings I'd been given, and then I met with Rob and his entire team. And then I met with the investigative team who outlined in PowerPoint form the case. A couple of things struck me immediately was the depth of the commitment of that law enforcement to finding those kids and then holding Chad and Lori accountable, and the absolute commitment of the Madison County Prosecutor's Office, its small office with good, hardworking lawyers, to really do right by these victims. Those things I will take away as really a testament to the strength of the system up there in Idaho.
Kirk, when we're looking at closing arguments and we're looking at the time 14 jurors, it seemed like Lori was reading. She went on for about 17 minutes. We couldn't really see her face because of her hair, but if you're, you as a defense attorney in the past, like, you zone in on one or two people, try to hone in on them, try to get some sort of empathy and connect.
Well, yeah, you always want to connect. You're hoping you're connecting with all the jurors to some level. By the time you get to closing arguments, you might have a sense as an attorney, what the jury thinks of your client through the questions, through what Rachel mentioned earlier, through some of the looks, what have you. You have a sense of that, right? So, you're trying to connect with all the jurors and you're trying to break through some of that. And it always depends on the type of case, right? Because and you don't know who the foreperson is going to be when you're making that argument, because that, that would be gold, right? Then you'd be able to focus right in on that person. But you can see to some extent sometimes who people are that maybe are taking maybe a leadership role in the jury. There's people that kind of seem to maybe taking a more prominent role in the case. So you're looking at speaking to them, but you're looking at speaking to all jurors, because you don't really know what a juror is thinking about the case, particularly if there isn't any questions or not. You might just be dead wrong. I mean, I've had cases where I thought a particular juror was the least likely to glom on to my argument, and in fact she turned out to be the most strongest advocate for it. So it goes back to what I'm saying earlier about juries. We choose them, or they're chosen as individuals, or not deselected, if you will, but there's really a group dynamic that takes place. So yeah, you could say you want to make that connection, but I think as a defense attorney, or even as a prosecutor, it's the same. You'd be remiss if you weren't addressing the entire jury, to try to stay on that train. As a defense attorney, you want to go from presumption of innocence to not guilty. So you want to drive that train as much as possible. And, I will say that, there's attorneys probably that have different theories on this, but I mean, I remember giving a closing argument for a couple hours with very little reference to notes, because you have to try to make that connection. Because the one thing that you do, whether it's you're looking at one or two jurors or the entire 12 juries, you want to be able to make eye contact with those jurors. You don't want to be able to read your closing, because it puts a space between yourself. Maybe I made Mel cough up with my comments, but listen, you want to make that connection with the jury, and a piece of paper is one way to really kind of build a wall towards it. And I see Ben smiling. I think he knows exactly what I'm talking about, because if you're not making eye contact, you're looking a little less assured of yourself. Because when you talk to somebody and you're sure of yourself, you're looking at them. But when you're not so sure of yourself, maybe you're looking down and going through the motion. And as a defense attorney, you never want to be looking like you're going through the motions.
So you went 2 hours one time for closing.
Oh, Justin, I can talk, man.
I know you can talk.
Set the timer. I can go 2 hours on Ben Taylor.
Yeah, that's true, Kirk.
Benjamin, yeah, same point and question as far as whether it's closings or openings, being able to command that jury to sort of stay with you and gravitate towards you and what you're going to present throughout trial or at the end of it. Can you tell us just about a time where you really nailed it?
Yes, I mean, in closings, you can tell when the jurors are smiling at you. Before they go to lunch, they stand up, they walk really past you into the jury room, and they might nod, they might smile at you throughout the case. When you're doing your cross-examination, you can look over because the juror's to your right, and you'll see a juror just nod and just like writing notes. When they're writing notes or like nodding, you know that they're with you. So you have to make that connection. And when Lori Daybell was doing her closing arguments, what's unique is, like your reporter Lauren Clark mentioned, right now is there 10 men and 2 women on the jury?
Yeah.
She's a master manipulator, right? I mean, she's been looking in those guys' eyes and been like talking to them and trying to see what she can do to maybe get a vote or something, right? I don't know if that will overcome that, but she has to pull out every string. That's what she should have done. Make that connection with at least 1 or 2 jurors and be like, you know what? This is overwhelming evidence, but something about that Lori I like, right? And all it takes is that one juror. Like I said, Kirk knows about that in Jodi Arias' trial, who's a strong, who will just hold out, who doesn't care about the rest of the 11 jurors, who will say, you know what? I'm so confused with all this evidence, I can't decide, and I'm going to hold out. And that's what Lori should have done in her closing, by looking at them and looking at them. But He saw her looking down a lot at her notes, reading her notes, kind of like being a little bit nonchalant. And that's what we talked about throughout these couple of weeks. That's her biggest harm, is that she didn't have an attorney who knew the skills to present this case in court, who could give her a fighting chance.
Benjamin always knew that he had problems when he looked out at the jurors and they're sitting there like this. He's making his
Mel, I mean, many times you have described Lori as charming and bright and articulate throughout this. I mean, there's out of the 10 men, and maybe we're totally wrong on this. I mean, these people could be just focused on the evidence, but could there be that charm factor?
Well, I'm sure Lori would like to have the charm factor. I just don't see how anybody can be charmed when you look at the facts that they're laid out. They're chilling. And so, again, when you look at her demeanor, I go back to her demeanor on the day of the death of her husband, her indifference, her cold nature. I think if she's trying to make eye contact or trying to charm the jurors, I would be real uneasy with that. I don't think that would be effective for her. She would have been much better having an attorney speak for her and to sit there staring straight ahead.
And Taylor, I mean, you dealt with Charles, her former husband, her fourth husband. I mean, how did he describe her? I know he was concerned. He was scared. But obviously, we know a lot more than we knew then. He was in love with her.
He absolutely was. He wanted to do anything he could to try to save the marriage because he loved her so much. And he kept telling me, this is not the woman that I know. This is not the woman that I love. This is not the woman I married and stayed married to for 13 years. His hand was forced to file for divorce. The Lori's bizarre beliefs and manipulation didn't just start when he filed for divorce. It started months previous, right? And it only came to a head once he started being locked out of his house and couldn't contact her, and then she's starting to say, hey, if you come here, I'm going to kill you and have an angel to dispose of your body. So, he absolutely loved her. And to speak to the charming factor, that he talked about that too. That's what worried him, because he could not get through to her family members because they all believed what she was saying. She spun a story that he was cheating on her with escorts during his business trips and had proof. And he kept demanding, show me the proof, show me the proof. And he's telling the family members, have her show you the proof. She's lying. I'm not doing that. I'm not stepping out on the marriage. She's the one who is making this up to get what she wants and manipulate you all. And Adam was the only one that would listen to him. And so that's why, when he tried to get Adam to do the intervention or to pull her temple recommend, it was because he loved her and he knew that she was, the puppet master of her family members. And she was just sitting there and manipulating the entire situation. And he was worried that she was going to be doing that with the police department. He had her held by community bridges for, an involuntary hold. He filed that petition with Gilbert PD. They took her to community bridges and they released her and said she's not a danger to herself or others. And she passed it, with flying colors. And I think that a lot of that is her charming personality that she had. And I was kind of shocked to see that wasn't, really put on display during the trial. And I think that we saw some of that, charm go away with the way that she conducted herself when speaking to the judge or speaking to some of the witnesses on cross-examination, so that jury can't really be charmed and manipulated by her. And then in closing, she was very rote. Obviously, she's never done a closing argument in her life. And so she's got to follow her script that she had jotted down on a notepad. And that really, I don't think, was personable. She wasn't looking at the jury. She wasn't interacting with them. She was just looking down and reading. And I think that's going to, ultimately, any juror that may, be on the fence, I think that's going to hurt her.
Great insight there. I mean, people have called her the Black Widow. Guys, don't go anywhere. I have a live shot for our new newscast in about 10 minutes, but for our panel, this is a time, take a break, leave your Zooms on. I'd love to have you guys on in a little bit because we are still on verdict watch. About an hour and a half, nearly an hour and a half, the jury has been deliberating. No sign of a lunch break yet, but we are continuing to monitor this. Those of you watching right now, you'll see me do my live report or talk back with the anchors in the news studio. But Benjamin, Mel, Kirk, and Taylor, thank you so much. Stay with us. This is just a water break, or you grab some lunch, grab a snack, but we are not going anywhere. Appreciate you guys. Rachel will be back on as well. She had to step out, but just want to let you guys know she'll be back on the panel for the rest of the afternoon as we wait for this verdict to come in. We'll see you in a little bit.